defined under Section 91 of Labour Act 204 as an agreement between two persons. One person agrees to serve the other as an employee, while the person being served is an employer. Welcome to 7 Legal. I am Olachi Anyukwa. Today on 7 Legal, we will be discussing contracts of employment, the welfare of employees and employers in Nigerian economic environment. With me to discuss on today's show is Barrister Chisom Ekwefi. Welcome, Mr. Chisom.
Yes.
Can you tell us more about Labour Act and what it represents for Nigerians?
Okay, the Labour Act basically it's the law that guides employment of workers in Nigeria, both the manners in which they are employed, the treatment during employment, how they are treated, and how these works are terminated. But basically, they guide the relationship between an employer and a worker in Nigeria.
Okay. When I was making researches for this show, I realized that there are different types of workers who are covered under the Labour Act.
Yes.
There are workers and there are non-workers. Can you explain to me which part of Nigerians' workforce does this Labour Act actually cover, and why does it cover a particular set of people?
Okay. The Labour Act defines workers in the light of people who do clerical works, or labor works, or contract of service, or personal contracts. But however, the definition section of Labour Act gives exemptions, 5 exemptions of people who are not contained or who are not expected to be workers, who should not be seen as workers, who do not have the coverage of the Labour Act. So basically, Labour Act covers only workers, and workers in the sense of Labour Act is defined in the sense of people who do clerical jobs, manual labor, contracts of service, or contract personally. Now, for the non-workers, there are 5 exceptions of people who are not workers. I think these are the people who we term as the workers. Now, professionals who are under public service employment, family members of people who are employed, people who are employed, workers who are employed, but they do not work on the employer's space, and people who are also employed by an establishment, but they do not work for that establishment, that is outsourcing. Now, it does not also cover market women, sorry, not market women now. It does not cover people who do their work personally. People like tailors who you take services to, and they do their service in their house. It doesn't also cover workers who work from home. It also does not cover people who work in parastatals where the aviation laws govern. People who work in aircrafts and vessels where the aviation law covers. The Labour Act doesn't cover them. But that does not mean that they go without remedies. The general principle of law, principle of equity is ibi jus ibi remedium.
Okay.
Once there is a wrong, a civil wrong, there must always be a remedy. So once somebody is aggrieved, there's an aggrieved party, once somebody is wronged in any way, there must always, at every point in time, be a remedy.
Okay.
You understand? Provided that a wrong has been done.
Yes. But I'm trying to, because this show is mainly to find a way to educate Nigerians who are working for people when there's a breach in the contract, what to do. There has been a recent, trend. It even trended a few months ago on Twitter about bad bosses. And I want to understand this. In the law, there's a section, I've forgotten a section of the law that says, probably 91 or something like that, of the Labour Act, that says if somebody is employed, before there's a termination of that contract, there has to be a notice. Probably a notice or not, or depending on the months or the years of work I know if you work for 1 month, it might be 1 to something days notice. But we have seen in Nigerians constantly and obviously that an employer comes up to just sack people like that. Is it right? Is there any issue? Is there anything to be taken up to court on that issue?
The issue of termination and the provisions of the Act, like I said before, the provisions of the Act governs only people, only workers, only people who the Act protected, who the Act envisaged, and that is workers. Now, if you're a non-worker, according to the Labour Act, if you're a non-worker, the first point of recourse should be the contract of employment. Now, what does the contract of employment says about
the contract of employment is the letter you are giving when you are employed.
Yes, your contract. Some people do give a letter. Some people just sign an agreement. Some people
say it orally.
Yes, say it orally. So, what was the agreement? How was?
Okay, to cut you short,
yes.
When is oral contract? Oral contract. When does it become binding? Because I have an incident that happened where somebody said it's because you said it orally. There was no written signed agreement into it. That is why you cannot take it up to court. So when does an oral contract become binding? Before we even get into
your ability to prove them.
Okay.
At every point in time, oral contract is always binding. It's one of the earliest principles of contract that a contract can be parole or written. So if it is parole, it is still binding. The question is, how do you prove them? Now, you prove oral contracts by actions that were taken immediately after that thing was said. You can also prove it by perhaps text message. When I mean text message looks like it's written. But when I mean written in the strict legal sense of drafting up a document. Now you can prove that by a text message, by an email message, by perhaps you recorded the conversation or somebody was there who heard what was said. So if you can prove that so and so thing was agreed upon orally, it's binding.
Okay. Before we talk about the recent issues that are happening in Nigeria, I have a scenario to discuss. A friend of mine had an issue with the boss. He was sacked, he wasn't paid. He took it up in court and it wasn't settled. But before we get into that, let's go on a commercial break. We'll be right back.
Thank you.
For advert placement, you can call the number on your screen.
And you can visit our website at www.7fm.tv.
7TV Nigeria.
7TV, it's all about you.
Okay, you're welcome back to 7 Legal. I am here discussing employment contract. I have a scenario that we are supposed to discuss on the show. And this scenario is a friend of mine had an issue. He worked for 5 years. And what the boss, in the period of those 5 years, what the boss will do is that he will work for 5 months. And the boss will pay like 3 months and owe him 2 months. He worked for another 3 months without pay. He will now pay for extra 1 month. Then there was a mass retrenchment, if you understand, and that he was sacked, and a lot of people were sacked. Then on the process of litigation, trying to get his money and everything, the boss died.
Okay.
The boss died, sorry. So in the process of this, in the Labour Act, is there any specification for entrenchment or how an employer should be entrenched?
Well, I'm going to answer this question in 2 ways.
Okay.
First of all, answer for the workers.
Okay.
And by now, we know that when I talk about the workers, I mean those who are protected under the Labour Act. Now, apart from the Labour Act, there are a vast majority of other laws that govern the principles of employment.
Okay.
Yes. So, but we are talking about workers in view of the Labour Act. Now, how do you terminate a worker in view of the Labour Act? The general principle of law is that he who fires he who hires can fire. You understand? So if I can hire you, I can fire you.
Okay.
That's the general principle of the law. Now, but the Labour Act states that you must give notice. If you want to lay somebody off, you know, it's good you give the person reasons why you are laying him off. And you know, reasons can vary. It mustn't be very serious things. You understand? So another reason why you can lay somebody off, why an employer can lay an employee off, could be that there was theft, there was mismanagement, there was all of this. Now, when it is that kind of situation, maybe there was theft, it was the resources of the company was badly managed. You first of all give the employee the opportunity to defend his or herself. Create a panel, meet the HR, query him. He should answer the query. When he was not answering the query and you are not satisfied, you can then go ahead but then you must take this processes first. Now, if it's just because the labor force is big, you know, there's a lot of and then you want to lay off some people, then you state it that this is it and you're part of those people who was affected. And when you lay somebody off in that manner, you must pay whatever you are owing the person. You must also pay the person fee in lieu of notice. In case you are not prepared to give the person the adequate notice that is provided, you pay him fee in lieu of notice. You pay him gratuity. You pay him every out-of-pocket expenses he has spent for the company. You pay him, and you pay him every other benefit that accrued to him. Those years he had worked that were supposed to accrue to him, you pay to him. Now, these are the people who are covered under the Labour Act. You know, workers, as we know it. Now, for the non-workers, the process or the procedure is relatively the same.
Okay, to cut you short, because this scenario, the person was being owed and still laid up without pay. What is the procedure? What's the person supposed to do?
The person is supposed to go to court. Now, the Constitution has provided that for labor matters, employment issues, the National Industrial Court is the best court, is the only court that has jurisdiction to hear this matter. So you go to court for wrongful termination, go to court for arrears, for payment of own salaries, and you know, when matters are heard, you provide evidences. You know, that you've worked for so years. You know, first of all, you'll be able to establish a relationship. You know, provide to the court, show the court the relationship between you and the former employer, that yes, you'll be adequately employed. You can do that by perhaps employment letter, contract of employment, or oral agreements and whatever, and or even payments the way he was paying you. You know, if somebody employs you and every first of every month we see a lot coming from 7 television, you understand, we can say that what is it that this guy does for 7 television that they pay him every month 10,000 naira, 20,000 naira every month consistently. It could also be a proof of that relationship. Yes.
You were talking about the human part, your own personal part about it.
The human part of it is that the Nigerian situation is terrible. There is a little work or no work, and there's a lot of persons available for work. And also making a case for the employers, the environment too is not favorable for work. Yes, if you own a pure water producing factory, you need power. And you find out that you spend 20%, 30%, 50% of your income to resources to buy fuel, to buy diesel, to maintain your generator, to, you know, these are ordinarily you would have spent less if the environment was favorable, was friendly. You had good roads, you had electricity, you would have spent less. By the time you are done doing these deductions and you see that you are left with little or nothing, you pay your workers from what you've earned. And you know, the workers who are being treated unfairly, most of them, they have no choice
Than to
collect, because come on, if you are not ready to work, if you do not want to work, another person will work. You understand? And even sometimes these multinational companies too, because of course there are also multinational companies who had more than 25 persons in the employment and they are making good monies and they still do not keep to minimum wage. Why? It's because there are no agencies. There are no agencies that regulate these, that look into these, that make sure that this happens. And the average employer will say to an employee, I did you a favor to employ you. But contract of employment are not supposed to be favors. They are not supposed to be. Somebody is offering rendering services. Whether or not you feel that he's doing nothing, you employ him, you can't sack him. If you feel that the services are not worth it. You understand? So it is a whole lot of issue.
Okay. If you are covered under the Labour Act and you are treated unfairly, you can go and sue.
Whether or not you are covered.
Whether you are not, you're covered.
Yes.
Oh, you can go and sue, right?
Yes.
And also, Nigerians are saying that there are provisions in the courts. Even if you don't have money to get to sue, you can go for pro bono. You can go and liaise with your lawyer. But I also beg the employers and the Nigerian government to make our working environment very conducive, because as more conducive it is for Nigerians, the better it is for us to produce good work environment. It is 7 legal, and today we talked about employment contracts. So you can follow us on our social media handles. It's already on the screen. Follow us on the social media handles. If you have any complaints or any issue for sponsorship or adverts or anything you want us to talk about on our show, you can call on the numbers. I am Olachi Anigwa, and I will see you same time next week. Do have a blessed day.